Yes.
Lords and ladies, I suppose a support role to Mr. Howard, so I'm going to be brief and obviously not trespass too much into our reply time. I adopt Celestial's oral submission. As far as the Constitution is concerned, the factual background is materially the same as Celestial. There were events of default that arose under the two leases in that case, and the lessor terminated the leasing of both aircraft. Terminating the leasing of the aircraft was to bring the right to possession and use of the aircraft to an end. The precise dates are set out in the agreed statement of facts, paragraph 17, which is pages 7 and 8. And I'm not going to take you to them now, but that's the reference for you. There were lease terms that made express provision for the letters of credit, and those are at, the material ones are at page 414 of the bundle. And it might be worth just very briefly looking at those. And essentially what you have at 414 clause 8 is a security deposit that is provided. And that security deposit is primarily provided in cash, by payment of cash. But there is then an alternative to give a standby letter of credit. And the same is then true over the page of maintenance reserves at clause 9.1, which is effectively a sinking fund for maintenance carried out. And then if one looks at clause 10.1, which is at page 416, your lordships will see that the security deposit and maintenance reserves and any letter of credit provided in lieu of cash reserves belong to the lessor. And so the scheme was effectively to provide security to the lessor and for the lessor to be able to treat it as its security. And I don't need to take you to the various demands that were made. They were materially the same as the ones you've been shown, save that I think for the Constitution one, they did refer to the events of default. So I should take you to that one of them, actually.
At least give us the page numbers, thank you.
I beg your pardon? Yes, page 511. And if you have turn up 511, your lordships will see that it refers to various clauses under which the defaults are said to have arisen. So that's insurance, breach of agreement. And then over the page is material adverse change. And then it sets out in bold as a consequence, the lessor terminates the leasing of the aircraft. And then it makes various demands. Now, this particular aircraft was in fact on the ground in Sharjah. And so it was to remain there, and the engines were in various maintenance organisations. And then your lordships will see after the numbered paragraphs, there's a clear, for avoidance of doubt, operation of the aircraft by a lessee after the date of receipt of this notice is not permitted. Lords, moving on, one of the key phrases you have to grapple with is in connection with. That is capable of a wide or narrow meaning depending on context and purpose. You've seen reference to Protean as a descriptor. You've seen also in our statement of case the London Luton Authority, where again, I'll give you the paragraph number and the reference, but I won't take you to it. It's page 1311 behind divider 46 of paragraph 69, where effectively the meaning to be given to that phrase is heavily dependent both on context and policy. In some cases, it may require a strong or close nexus, in other ones, a loose one. So can I then take you straight to Regulation 20.
So is it the page of the authority you just cited?
Oh, I'm so sorry.
1311.
1311. And it's a judgment of Lady Justice Falk in the Luton case.
Thank you.
And she's giving at 69 the summary of the different cases and making that observation that I just stated to the court.
Yes, well, dealing with context, what do you say the words in pursuance meant?
My Lord, I was going to come on to that, but I can...
Okay, well, come on to it when you're ready.
I'm going to address that. So one then turns to perhaps Regulation 28.3c, which is at... I should know this off the top.
595.
Thank you. And our submission is that the terms "in connection with" do require a causative link between the funds and the making available in Russia of an aircraft. And we say that the causative link or a strong nexus is intended because the relevant arrangement is confined to one which has the object or effect of making the aircraft available in Russia. So the funding that is being sanctioned is in a causative relationship with the mischief of making an aircraft available in Russia. And the use of object or effect ties the intended purpose of the arrangement to the actual financing that is being targeted. In other words, the breadth of the sanctioned finance is delineated by reference, by the use of the words object or effect on the arrangement. And it's also relevant that that is contained within the wider set of sanctions that prevent the supply of aircraft to Russia. So that's the relevant context in which one is looking at this additional provision. So not only has the legislator stopped the direct supply of aircraft, but also any associated finance for the supply of aircraft. And we say that the requirement for a causal link is also consistent with the purpose of Regulation 28, which is to stop financing of aircraft that are going to be made available in Russia. Now, there are other parts of this regulation which have used different language, such as enable or facilitate, and UniCredit have identified at least 3 examples. But what I would say about those is that they are different provisions, and they don't have language that has arrangement that is then defined by object or effect. And in our submission, when you look at this particular clause and you look at how the legislators drafted arrangement with the object or effect of making aircraft available, it has the same effect of using enable or facilitate. My Lord, I'm going to come on then to the point that my Lord Hodge asked me. The construction of in connection with does not, in our submission, render in pursuance of redundant. So these are 2 connective terms, and invariably they are areas of overlap between them. But in pursuance of is directed to finance that is provided pursuant to or under the terms of a relevant arrangement. And just pausing there, arrangement is defined in Section 2 very broadly, so it could be a single transaction or it could be a series of transactions. But if one were to look at this case, it's clear that in pursuance of an arrangement would catch the letter of credit itself. So if one were taking the point of the payment under the letter of credit, that would be caught by in pursuance of.
Sorry, it's my fault entirely. What did you say in pursuance of meant?
In pursuance is provided under the terms of or in accordance with the terms of a relevant arrangement. So, for instance, one could see an opening of the issue of a letter of credit on the 5th of March for a supply of an aircraft in Russia. The payment that is then made under that letter of credit would be in pursuance of a sanctioned letter of credit. That doesn't apply in our case because obviously the letters of credit were issued before these sanctions. In connection with, on the other hand, is a wider phrase than in pursuance of, and it extends beyond financing that is provided pursuant to the terms of the relevant arrangement. So except there has to be an association, but the use of object and effect later in the clause, which applies to both connectors, does in our submission restrict the connection to one where there is a strong nexus or relationship of causal support. So for instance, again, if you take our case, the payment, and I agree with and accept Mr. Howard's submission that a payment under a letter of credit is capable of being sanctioned if it is, has the effect of making an aircraft available. But if one were to look at that payment, that would be in that illustration in connection with the lease. So the letter of credit is satisfies the in pursuance of, and the lease itself satisfies the in connection with. But in both cases, there needs to be a causal link to the making available of an aircraft in Russia.
But that depends on you saying that in pursuance of doesn't bear one of its normal meanings. It can, of course, mean as part of the carrying out of an arrangement, which I think is what you're saying it means in this context. But it can also mean in order to do something or with the aim of achieving something. And if the words have the latter meaning, then would that not cover the causality, leaving in connection with as an extension for some other purpose?
I mean, I would accept that there is overlap, but I don't accept that it renders in connection with redundant, or I think in connection with also entails a connection that is not related to the particular arrangement on which the payment is being made or the funds are being provided.
But where do we get, if in pursuance of has that causal meaning in this context, and that of course is a matter that the court will have to consider, but what is the broadening of that phrase by the words in connection with?
In my submission, in connection with is looking to a transaction that is not the payment instrument itself, because we are looking at financial services or funds here. So it is associated, that the funds are being provided in association with another arrangement. And it's driving at whether the payment that is being made or the funds that are being provided are themselves making the aircraft available or enabling the aircraft to be made available in Russia. My Lord, these are broad terms which are capable of being given overlapping interpretations, but just because there is overlap, it doesn't mean that one has to take an unduly broad interpretation of the of one of the connectors.
And so, are you saying that in connection with refers to some other arrangement apart from the one that in pursuance refers to?
Well, I think it's capable of doing it. I mean, the way it's drafted, I think, is it's capable of covering overlapping positions. But certainly the letter of credit is given under the lease. So but the payment under the letter of credit is strictly under the letter of credit itself.
And so an arrangement in 28.3 is, what's the arrangement in this case?
So looking at the facts, there are effectively two transactions that could fall within the scheme. The one is the letter of credit, but that's obviously not caught because it was issued before.
You mean the opening of it?
The opening of it. The second, then, is the lease, which is broad enough or the definition of arrangement is broad enough that it could capture a series of transactions. And so the relevant arrangement for the payment under the letter of credit in this case is to look at the lease. But one has to look at both, obviously. And here it is the in connection with connector. But one still then has to ask the question and give effect to object or effect to the actual funds that are being provided. And then the next point in the clause that is worth looking at and supports this submission, and it comes back to a point that my Lady Simler raised with Mr. Howard, is the temporal link that is required. And one sees that in the language here, where it says at subparagraph 3, whose object or effect is directly or indirectly making. Now, the tense, we say, is important, because it's effectively is making available. And that shows that there's a deliberate intent to identify and capture a current and continuing act of making an aircraft available in Russia. It's not concerned with a historical supply or something that occurred prior to when these sanctions came into effect.
Well, yes, I've been puzzling about that, but just to put a point against you, I mean, suppose you have a lease that starts after the 1st of March 2022, runs for 3 months, comes to an end, and then the rent has to be paid on that. So the lease has come to an end, but save for payment of the rent under a letter of credit. I mean, I would have thought that although the arrangement itself has come to an end, you'd still be caught, wouldn't you, by Regulation 28.3 with regard to the payment under it?
Absolutely, because you have to look at the reality of the arrangement. Now, the arrangement
the reason for raising that is that I'm not sure that you can give the word is at the end of Regulation 28.3 introduction, the meaning which I understood you to be trying to give it, that it's referring to something which is ongoing at the time when the payment falls to be made.
No, that wasn't what I was suggesting. Okay. What I'm suggesting is that the arrangement of making the aircraft available is ongoing. And that's for
but it wouldn't. Sorry, in my example, it wouldn't be ongoing because the lease has come to an end.
No, but the payment would relate to the making of available of an aircraft at a time when it was sanctioned.
But I'm sorry to pick you up on this, but it may be an important point. But isn't that to read, in effect, the introductory words of sub-regulation 3 as though it was an arrangement which is prohibited by these regulations, which could have been done, as opposed to the text which is there, an arrangement whose object or effect is the export and so on?
I mean, I don't think it is actually, because I think what one is doing is that you take is directly making restricted goods available. So the arrangement that is being looked at for analytical purposes is one that is making an aircraft available.
We're debating the temporality of that. So, I mean, what I was putting to Mr. Howard is not the more natural reading of that one looks at the arrangement when it is made and says, well, is this an arrangement whose object or effect is the export of restricted goods and so on? In other words, the temporality associated with is directed to just looking at the arrangement itself when it's entered into or maintained. Whereas, as I understand your submission, you seem to be saying that the impact of the word is to confine it to arrangements which are made after the coming into effect of the regulations.
Well, arrangements that have the object or effect. I think you have to read it with object or effect, because that does then tie what is being what is relevant to triggering the sanctions is the making available of a restricted good in Russia. So If the arrangement is one that makes available after the 1st of March, then that is one that would be caught, even if it has come to an end and the payment is made subsequently.
Right, thank you.
I mean, one has to look at it this way. I don't think it was intended, and it certainly would need to be made express if this was supposed to be retrospective. So suppose you had a lease of an aircraft, and I think Mr. Howard gave this example, which it would fall as an arrangement, but the aircraft had come to an end. The aircraft had been redelivered prior to the 1st of March, and the payment was to be made in relation to that prior leasing period.
But after the 1st of March.
The payment would be after the 1st of March.
So it's not retrospective in that sense.
No, but the arrangement that it's looking to catch is one that is in the past where there is no longer a making available. I mean, one has to step back and say the purpose of this is to try and stop the ongoing or continuing supply of aircraft to Russia and the future supply of aircraft to Russia. And that's entirely consistent with the aim of trying to put pressure on the regime to change its conduct. My Lord and Lady, there wouldn't in our submission with our construction be any lacuna or any gaps in the application of Regulation 28.3, because any financing that enables restrictive goods to be made available in Russia would be caught. And I think that comes back to the point my Lord Sales was putting to me, which is that if the aircraft has been made available after the 1st of March, then the financing or the payment that is due to be made would be caught, because it would have had the object in effect of making the aircraft available. The next point is, insofar as the bank's position is concerned, in our submission, the fact that the payment is something that would have to be looked at, and whether it requires investigation by the bank, that wouldn't militate against our interpretation, because the sanctions obviously impose a role of due diligence on banks and financial institutions. And it's common for those institutions to carry out some due diligence to investigate whether the payment is to be made is subject to sanctions. And that's precisely what happened in this case. And indeed, you've seen that in the interveners examples. In each case, the party that is responding to a demand or a payment is carrying out its own due diligence. And in any application to the licensing authorities, the bank is going to have to present the outcome of its due diligence and the conclusion that it's reached. And one sees that in this case. If one looks at the application that was made by UniCredit to it made its application to two authorities. One of them was the ECJU, which deals with trade sanctions. One can see that at page 485 of the bundle. And 485 is the start of the application. And then one picks up at 487. Where on the 7th of March, UniCredit advised AirCap that it considered the payment could not be made and requested further information from AirCap. And then sets out the information was provided. So although it goes beyond what a letter of credit connotes, where you have cause to suspect that sanctions are raised, then there is an inquiry that's carried out, and that inquiry is part of the regulatory obligations on the banks, and that's what happened. A further reason why our construction of in connection with is the correct one is that the broad factual connection that is being advocated by UniCredit does lead to uncertainty, because it says nothing about the strength or the nature of the connection. It has potential to apply to transactions that don't fall within the purpose. That's particularly unsatisfactory where there is a risk of criminal sanction. And it's no answer, we say, to simply say, well, there's a licensing regime, so cast your net wide and hope for the best of the licensing authorities. In our submission, the first question is what is the meaning of in connection with? And the language there is not affected by the fact that there is a licensing system, because that licensing system could be said to be there to apply to sanctioned transactions, and a filtered approach where it is one that clearly engages the purpose of the sanctions is the one which the licensing authorities want to allocate their resources and time to dealing with. And you've already seen the practical difficulties that result if you take an overly broad approach. One sees the facts of this case, where what should have been paid in 5 days was not paid for 8 months. And then you've seen the interveners examples, where there are at least 8 examples given of the delay and the effect that's had on the political insurance credit market. My lords and lady, unless there's anything else I can assist you with, those are the submissions I intended to make. And I'm sorry they've been rather rapid.
Oh, that's no criticism at all of you, Mr. Hobson. Thank you very much.
It's Mr. Shah.
Sorry, Mr. I do apologise.
Sorry,
Mr. Shah,
I'd like
yes.
to follow Mr. Howard.
I do apologise, Mr. Shah. Mr. Quest.
My lords, my lady, can we begin, please, with the wording of the regulation, which you have at page 595? So if one looks at Regulation 28.3, it is framed so as to prohibit the provision of funds if 2 separate conditions are satisfied. The first condition is that there must be an arrangement whose object or effect is making available restricted goods to a Russian person or for use in Russia. And the second condition is that the provision of funds must be, quotes, in pursuance of or in connection with that arrangement. And to be clear, the arrangements that we rely on are the aircraft leases. The various arguments which are raised by the appellants in their written cases and in their oral submissions can, in my submission, logically be marshalled into 2 groups. Those arguments which, properly understood, are about whether or not the aircraft leases are properly to be treated as arrangements for the purpose of the regulation, and those arguments which are about whether there is a connection between the payments under the LCs and the leases. So going to either one or other condition. And what we propose to do is to work through the arguments you've heard by reference to those points. The general approach to statutory interpretation, as Mr. Howard said, should not be controversial in this case. We would respectfully endorse the way the Court of Appeal approached it in paragraphs 50 and 51 of the judgment, in turn relying on Lord Hodges' statement of the principles in Crown and Secretary of State for the Home Department. So, on the question of arrangements, the appellants argue that the leases should not be treated as arrangements for the purpose of the regulation, essentially based on three criteria. First of all, they rely on the legality of the leases, or the legality of the supply or making available of aircraft pursuant to them. So they say it's not a relevant arrangement for the purpose of the regulation if it's legal when it was made or when it was performed. And then there's a second argument, related argument, about the timing of the leases or the timing of the supplies. And they say it's not a relevant arrangement if the lease was made or performed before the 1st of March 2022 when the amended regulation came into force. And then third, they rely on the termination of the leases, and they say they cease to be relevant arrangements for the purpose of the regulation once they've been terminated. And I'm going to go through each of those points. So, looking first at the question of legality or lawfulness, using lawfulness, either of in respect of the arrangement itself or in respect of the supply or making available of aircraft underneath it, is fundamentally problematic. And the reason I say that is because of the discussion that we had this morning, which is that first of all, the making of an arrangement for the supply or making available of aircraft to a Russian person is not in itself unlawful under the regulations. What is unlawful under the regulations, in particular under regulations 24 and 25, which you were shown this morning, is the actual supply or the actual making available of aircraft to a Russian person or for use in Russia. But, as was common ground this morning, that is unlawful only for a UK person or where the supply or making available involves conduct within the UK. So it doesn't have extraterritorial effect, and that's provided for under Regulation 3, which again you were shown this morning. And what that means is that it is, and always was, perfectly lawful as a matter of English law for, to take an example, a Bolivian person acting outside the UK to supply or make available aircraft to a Russian person, or to make an arrangement with that object or effect. And an important function of Regulation 28.3 is to deter or disrupt such arrangements by prohibiting the provision of funds either in the UK or by a UK person in connection with that kind of arrangement, even if the parties to the supply arrangement may be territorially out of the grasp of the regulations and so not themselves acting unlawfully. That's an important purpose of Section 28.3. And that being so, if one were, as the appellants say you should, to make an exception for either lawful arrangements or lawful supplies, that would seriously undermine the efficacy of Regulation 28. And for that reason, in our submission, lawfulness or legality cannot be regarded as in itself a touchstone for the application of Regulation 28.3. That's looking at it from a purposive consideration, but it's also important that the appellant's argument that there should be an exception based on the lawfulness of the arrangement or the lawfulness of the supply also finds no support at all in the wording. We have it in front of us. Relevant arrangements for the purpose of 28.3 are specified by reference to their object or effect, not by reference to their legality or to the legality of their object or effect. It's also worth noting generally when we consider exceptions and exclusions that there is, and we see this at page 571, just in the contents of the regulation, a long list in Part 7 of exceptions of one sort or another. We don't have them all in the bundle, but you can see, for example, that there are exceptions applicable to these trade sanctions at 60C in relation to aircraft and vessels, none that are relevant to the case. But where the legislators wanted to make exceptions to these regulations, they had a specific mechanism for doing so. Now, going back to 595 and the wording of the regulation itself, it is true, and this is something that is relied on by the appellants in their written case, that arrangements, when specifying what constitutes a relevant arrangement, Regulation 28.3 uses the term, quotes, restricted goods. But in my submission, that can't be read as implying that the regulation only applies where the goods are, or where the goods in question are of a kind that could not legally be supplied or made available. The term restricted goods, as the Court of Appeals said, is simply a label for convenience to refer to particular types of goods, including now aircraft. It was introduced in March 2022 to replace the previous label of military goods. And all it does is simply to expand the list of types of goods with which the regulation is concerned. So, in our submission, there is no justification for using lawfulness or legality as a criterion for disapplying 28.3. One then turns on to a related argument advanced by the appellants, which is that 28.3 should be limited by reference to timing. What is said is that 28.3 does not apply to existing arrangements, in other words, those that were made before the 1st of March 2022, or at least it does not apply to existing arrangements where the relevant supply had been made and completed before 1st of March 2022. So in other words, that argument seeks to impose an exception or a limitation on 28.3 based on timing rather than lawfulness per se. Again, there is absolutely nothing in the wording of 28.3 which indicates that the legislators intended such a time-based exception or exclusion, which was the point the Court of Appeal made at paragraph 57 of the judgment and in our respectful submission correctly. The absence of anything in the of any express exception in the wording of the regulation dealing with pre-existing arrangements is significant, in particular because the issue of how to deal with existing transactions and how to deal with existing rights and obligations is a very familiar one in the drafting of sanction schemes. It's a familiar problem for legislators to have to decide what to do with existing arrangements. And one can see that different approaches are taken in different areas. Sometimes we see legislation that expressly provides for a carve-out or exception for pre-existing arrangements. Sometimes we see a grace period. Sometimes, as in this case, there may be the opportunity for a party to apply for a license or a dispensation. These are all different ways of dealing with the potential problem or potential unfairness caused by a sanction interfering with an existing arrangement. And indeed, there may be cases where legislators simply take the view that the overriding importance of the policy objective in enacting the sanction means, and I use the words of Mr. Justice Carr in Crown and HM Treasury, which we have in our written case at paragraph 79, he said innocent people may become victims of the sanctions regime without having done anything to deserve their suffering. And that's just a reflection of the fact that we are in an area driven by policy. I won't take the court to them all, but we have in our written case at paragraphs 40.1 to 40.3 given examples of the various different approaches that legislators have taken to the pre-existing arrangement problem. For example, the Syria regulations, Syria sanctions and the Belarus sanctions have express exceptions for existing contracts. And the EU regulations provided for a grace period. And indeed, there are time-based exceptions within the Russia regulations themselves. For example, if you turn to Regulations 17 sub 5 on page 585 of the bundle, you will see that this is to do with loan and credit arrangements. Within the definition of Category 2 loan, which is about 3/4 of the way down the page, you'll see at little c, there is a carve-out for, or it only applies to loans granted at a time on or after the 1st of March 2022. So there are many different ways in which the legislators could have carved out pre-existing arrangements from Regulation 28.3 if they had wanted to do so. And as I say, it's a familiar problem and something which is addressed in different ways. But what we do say is that against that background and in that context, absent any express exception based on time of supply or time of arrangement, there is no reason to suppose that the legislators intended to exclude from the scope of Regulation 28.3 arrangements that were made or carried out before the 1st of March 2022, or indeed to impose any timing-based on the operation of the regulation. On the contrary, the obvious inference, we say, is that the legislators intended that the regulation should encompass all arrangements of the kind described in 28.3, that is, all arrangements whose object or effect is the supply of aircraft to persons connected with Russia, and that if that would result in what one might regard as a hard case, in other words, a disproportionate disadvantage to someone who was already committed under an existing arrangement, then those hard cases would be addressed by, through the licensing regime, by the application for a license. And indeed, that is supported by the Russia guidance, the statutory guidance issued in respect to the regulations under section 43 of SAMLA. And perhaps I could just show your Lordship and your Ladyship that guidance. You'll find it in the bundle at page, well, it begins, it begins on page 621. This is guidance which there's a statutory requirement to issue.
So what is the date of this guidance?
The date is
31st March.
31st of March, yes.
Well, that says updated, but
It's not the original.
It's not the original. I think it's the first one that was issued after the regulation.
The first one after 1st March. Yes.
Right. So I'm reminded, in fact, there was a version on the 25th of March as well.
Yeah.
But I don't think we have it in the bundle, and I don't think it's in different terms, at least not so far as relevant to the point I'm about to make. The point I was going to make is if the court goes to page 650, you should have a heading licensing for trade sanctions. And if you go 4 paragraphs down, you'll see the guidance says for some prohibitions, there are some specific activities that DIT considers are likely to be consistent with the aims of the sanctions. These are set out in the table below. If you think your proposed activity falls within one of these descriptions, you should make this clear and explain why you believe this to be the case in your application for a license. So this is not saying they're going to give you a license, but there then follows a long list of kinds of transactions which I think the implication is the licensing authorities might look more favourably on. And so far as relevant to the present discussion, if you go to page 673, you'll see that there's a section governing the provision of financial services or funds relating to aviation goods. And it says a license may be granted for the provision of technical assistance, brokering services, financial services, or funds related to aviation space goods if the Secretary of State is satisfied, ... that it's necessary for the execution of obligations arising from contracts concluded before the 8th of March 2022 or ancillary contracts, provided the activity is completed before the 28th of March 2022. So I show that just for the purpose of indicating that the concept that you might get a dispensation or a license based on the timing of your contract, and in particular whether it was pre-existing, either at the time of the sanction or shortly afterwards, it is something that's reflected in the guidance.
It refers to the 8th of March. That's the date of Regulation 29A, is that right?
I think that's right. It's the date where there was a further amendment. It must have been to bring in 29A. There is also another provision, which it's not easy to read them together, but just so you have it all, that on page 667...
Just before you leave that, why is it saying the licensing ground will no longer be available from the 28th of March, do you think? Because
the activity has to be completed before the 28th of March. Do you see in the line above?
I thought your argument was that this is a general point, that you could go off and get a licence, even though what had actually been sorted out was before the 1st of March.
Yes. I think what...
If this was being used as an example, there shouldn't be any 28th of March cut-off, should there?
Well, I think that's because it's a sort of grace period for you to do it by then. In other words, if you're going to rely on the fact that you have that you need a license for an activity that you were already committed to doing under a pre-existing contract, right, you need to have completed that activity by the 28th of March. So if you're saying, for example...
Completed what activity?
Sorry?
Completed what activity?
Presumably the activity under the contract, under whatever contract it is that you're seeking license for. So,
which contract are we talking about here? The letter of credit or the lease?
In this situation, the license was obtained in order to perform the letter of credit.
And how do you complete that activity before the 28th of March?
Well,
or is it just a badly worded exception?
Well, the purpose for showing you this exception is not to say that this is the only ground on which a license could have been obtained. And in this case, I don't think there's any suggestion that it was obtained by reference to this particular ground or explanation. The point I'm making by showing it to you is to say that in answer to the appellant's point, that this couldn't sensibly have been expected. The regulation should be interpreted as applying to pre-existing arrangements, because that would give rise to some unfairness.
And presumably there's a general discretion with regard to the grant of licenses.
Yes, yes.
There would be various public law obligations which apply in relation to the grant of those proper purposes and so on. And it may be that in this guidance, within that discretion, specific points are made which, I don't know, arguably could give rise to legitimate expectations or so. In other words,
yes,
to improve your arguments for a grant of a license if you comply with the particular terms set out in the guidance. But that's not to say that you couldn't succeed on some other ground.
exactly. And I don't wish to put too much weight on this, because I'm not saying, as I say, I'm not saying this was the way the license was obtained in the present case. I'm simply giving it as an example of the argument I was making, that where one's dealing with pre-existing arrangements, there are different ways in which one can approach it. One way is by banning it but allowing the parties to apply for a license based on the fact that the arrangements are pre-existing. And this is an example of one way in which the licensing, or which...
This whole list was preceded by the words that we are dealing with matters, activities that are likely to be consistent with the aims of the sanctions.
Yes.
So that it's not an exclusive list. If you don't meet a criterion, all that DIT is doing here is giving you an indication of what's likely to be acceptable.
Yes, and as I said, I show it to you to answer the point that the appellants make, which is to say, well, you can't sensibly interpret the Regulation 28.3 as covering existing arrangements, because that will be unfair to parties who had such arrangements. But of course, the answer to that is that the way the legislators have approached it in our submission is to allow them to apply for a license.
You go. Which is the provision which governs the grant of licenses?
In the regulations,
yes.
It is it's in Part 7. Well, actually, so if you go back to 595, first of all, it's 28.6. Paragraphs 1 to 3 are subject to Part 7, exceptions and licenses. And then the license provision is at page 610, Regulation 65.
Thank you.
So that's the source of the jurisdiction for licenses. So
if you don't get a license, you are guilty of a criminal offence.
Yes.
You're locked up for 10 years.
Yes. Yes.
Okay.
Serious.
Subject to judicial review.
Yes. Yes, but it's
And the criminal court has absolutely no power to make that decision.
No. But it is, of course, a serious matter, and for a party in the position of UniCredit, something obviously to be very carefully considered. It's not in any way optional.
I think you were referring us to page 667,
yes.
when you've got a series of questions.
Yes. Yes, just so you have that in mind, because that also appears to be applicable, because that relates to the provision of critical industry goods. And again, I just mention it because, again, it has a reference to the date on which the contract was concluded. So again, suggesting that what the legislator had in mind is that if there were issues arising from pre-existing arrangements, they would be dealt with through the licensing scheme. So that just now turning still on this question of timing and whether there's an exception for pre-existing arrangements, it's also consistent with the purpose of the regulations to support an approach where, in principle, pre-existing arrangements or payments in connection with pre-existing arrangements are prohibited subject to license. Now, certainly, where one's dealing with a pre-existing arrangement that involves or might involve a future or continuing supply of aircraft, then the position seems fairly straightforward, because the purpose of the regulation is to deter or disrupt such activities. And if you've got a pre-existing arrangement but which might still result in supplies or making available, it's only right the regulation should apply to that. But if I might just try and tackle the point that the appellants pressed a number of times, which is what happens if you've got an arrangement that's been fully carried out before the 1st of March 2022, And the appellants sort of press what was really a kind of reductio ad absurdum, where they say, well, the Court of Appeal's approach would end up criminalising payments for a supply or a lease of aircraft, even if the aircraft had already been returned to the owner or lessor before the amendment came into force. And they say, well, that would be absurd, or it would be perverse. And obviously one answer to that is, well, the answer is that in a case like that you could apply for a licence. But there is also some purpose, even in that respect, in prohibiting payments. The purpose of the regulation, we saw it in Regulation 4, is stated in very broad terms. It's to discourage Russia from destabilising Ukraine. One way in which that can be advanced, in principle, is by generally disrupting economic relations between Russian buyers or lessees of restricted goods and those who may be prepared to supply those restricted goods to them. And it's quite possible that a supplier or a lessor, perhaps one based in a jurisdiction more friendly to Russia than the UK, may be discouraged from entering into further transactions with Russian parties if he's left out of pocket because he's not able to obtain payment in connection with a historical transaction, even one that's already been completed. And you've already shown the statutory report under section 46 of SAMLA. That was at pages 561 to 562, which stated the purpose very broadly as being intended to, quote, constrain Russia by disrupting strategic industries such as aviation. So one can't necessarily assume that just because the aircraft has already been, or the aircraft supply or lease arrangement is already over, that there isn't a purpose to be achieved by stopping the supplier from getting paid. Now, it may not achieve the purpose in this particular case, because Celestial, of course, is not the kind of company that's going to want to supply further aircraft to Russia. But we know that this regulation has a very broad purpose. We know that it's intended to disrupt supplies from suppliers in countries which don't have any restrictions on supply to Russia. So it's not absurd to suggest that the legislators might have intended to, or did intend to, prohibit all such payments, subject, of course, to the possibility of an application for a licence. Moreover, one must, of course, be cautious about interpreting a sanction by reference to individual cases which might seem on their facts to be unfair. It is, of course, possible to construct particular scenarios where the application of Regulation 28.3 might not appear to advance the legislative purpose. But the existence of what we might think of as false positives doesn't, in our submission, itself justify interpreting the wording so as to exclude every such case. The purpose, when one considers the purpose and one looks at the purpose as stated in the regulation, the purpose is concerned with how the regulations apply generally across the board, across the whole spectrum of transactions. And one's considering what message is signalled to Russia and to those who deal with Russia. And one can't, given that breadth, in deciding whether the regulations apply in any particular case, it will be wrong to effectively substitute the statement of purpose for what the wording provides. And of course, one construes the wording in the light of the purpose, but the purpose is not a substitute for it. And it is important to have in mind the general point that we are considering legislation which is being used as a tool of government foreign policy, including in vital areas of national security and international security. In those areas, it's no doubt necessary for the government and legislators to act quickly, decisively, and forcefully. And it's entirely rational for legislators to accept that the risk of an occasional false positive, if I can use that expression, is a price worth paying for the foreign policy objective, particularly in circumstances where any hardship can be mitigated through the licensing system. And that, in my submission, is what the Court of Appeal had in mind when they described the sanction as a, quote, relatively instrument. And of course, the existence of the licensing regime is relevant in considering interpretation, because if nothing else, it shows that the legislators understood that there would be transactions that are caught by the regulations, but which on further examination did not infringe its overall purpose or policy, and therefore ought to be permitted by the grant of a license. And so when one looks at interpretation, one needs to look at it against the background of the existence of the licensing regime, because that may justify an interpretation that might otherwise seem to give rise to a disproportionately harsh result in particular cases. In that respect, there is one case, one authority that I'd refer the court to. It's Shanshal and Al-Kishtani, 2001, 2 All Englands. We have that at page 874 in the Court of Appeal. It's a case about Article 2 of the Control of Gold Securities Payments and Credit Directions in Iraq. And in summary, the regulations prohibited certain payments if they'd been ordered by a resident of Iraq, except with the permission of the Treasury. And the question which arose in the case is whether the regulation applied to persons who were residents in Iraq when the regulation came into force. And the question was whether the regulation ceased to apply to someone if they later ceased to be resident in Iraq. And if I can just show your lordships what Lord Justice Ricks said in the judgment beginning at page 888. He, in considering the effect of the directions and how they should be interpreted, he first of all recorded at paragraph 75 at the bottom of the page the submissions that had been made about the purpose of the regulations, of the directions that he took into account. And then over the page, at paragraph 76, he said that the breadth of such control, that's the control given by the directions, of course sets up innumerable questions as to whether in any particular case or category of cases it's in the national interest to maintain the statutory prohibition, or whether it's appropriate to make an exception. All such questions are delegated to the Treasury, in practice of the Bank of England. Thus, the control is both deliberately broad in principle, but also flexible in practice. In Boissonvane and Weil, where the 1939 regulations were an issue, the House of Lords was pressed in the most deserving of cases by a similar argument. But Lord Radcliffe said, the range of what they prohibit, so understood, is indeed exceedingly wide, and it's that very width that lends plausibility to the suggestion there must be some implied qualification. And then he says, 4 lines down, and here I would add that when a regulation contains a general dispensing power, such as the power that's given to the Treasury by Regulation 2, it's very difficult to press to a result any argument for a interpretation which is based on the absurdity of its literal construction. So it's always relevant to take into account in interpreting a regulation of this kind that there is an option to apply for dispensation or licensing. And more generally, as you will have in mind, the licensing regime has been described generally as what's called, I think, a safety valve in Schwidler, as it obviously is. So, for those reasons, we say if one's looking at the appellant's objections based on timing, the arrangements, the leases, cannot be excluded from the effect of the regulation only because they were made or because they were carried out before the 1st of March 2022. That's just not what the regulation says. So then the third criterion the appellants seek to rely on to take the leases out of the scope of the regulation is to say that even if the regulations might have applied to the leases before their termination, it ceased to apply by the time that payment became due under the LCs because there'd been a termination in the interim. And that argument, at least in the Court of Appeal, and it appears still here, was partly based on the wording of Regulation 28.3 itself. And this is the point that my Lord Sales was discussing earlier on, which is the effect of the present tense in 28.3 and the specification of an arrangement as being something whose object or effect is the making available of aircraft to a person connected with Russia. And it is said that once the leases were terminated, they no longer had that object or effect. Now, the Court of Appeal approached this at paragraph 63 of the judgment by saying, correctly in our submission, that the expression whose object or effect is at least insofar as it refers to an object, is simply a descriptor of the type of the arrangement, whenever it might exist. And they said, again respectfully correctly, that if one's asking what is the object of the leases is, and always was, the making available of aircraft for use in Russia. That's self-evident. That's the nature of a lease. And one might further bolster that conclusion by observing that it is significant that Regulation 28.3 refers to the object of the arrangement, not to the object or the intentions of the parties to the arrangement. And whereas here the arrangement is a contract lease, in our submission, the object of a contract is something that is determined when the contract is made by ascertaining, objectively of course, the intentions of the parties at that time. Now, as the contract moves through performance, its object may be achieved, either in whole or in part, or it may not be achieved, but it remains the object of the contract. And it doesn't, in our submission, make sense to say that the object of a contract changes unless perhaps the contract is formally varied. And so, in the case of an aircraft lease that we're concerned with, the object is to make aircraft available to the lessee on the terms of the lease. That's always the object. It doesn't cease to be the object because the lease comes to an end. Whether that is by the exercise of a contractual right to terminate, for example for default, or whether it comes to an end for some other reason, such as the expiry of the primary lease period, or the exercise of an option to terminate by one or other party. And if I might pick up Lord Sales's point, one takes, for example, of a 3-month lease which simply expires in accordance with its terms and the aircraft are returned. The object of the lease doesn't change, it's simply achieved its object. Now, if a party to a contract gives notice of termination, then presumably that party no longer intends that the aircraft should continue to be made available. But that's a change in his intention, the party's intention. It's not a change to the object of the lease. So the short answer to this point is that the object of the lease is at all time to make available aircraft to a person connected with Russia, and that brings them within the scope of the definition of arrangements. That conclusion, again, is also supported by thinking about the purpose and the practical effect of the regulation, because if the appellants are right that simply by, once the lease or the relevant arrangement is terminated or comes to an end, that takes it outside the scope of Regulation 28, well, that would seriously diminish the efficacy of 28.3. It could not act as an effective deterrent or disruptor of arrangements for the supply of aircraft if an arrangement could be removed from the scope of the regulation by the simple expedient of deferring payment until after the supply or the lease had terminated or had been terminated by the giving of notice. And that was the example which the Court of Appeal gave at paragraph 64 of their judgment. And it's an example which, in truth, the appellants have no real answer to. The most that one gets from the written cases is at paragraph 62 of Celestial's written case, where they say that if one was in a position where payment was made after the arrangement had been terminated, it could still be prohibited under Regulation 55, which is the regulation which prohibits activities that have the object or effect of circumventing other regulations. But that doesn't really seem to address the Court of Appeal's point, not least because the circumventing regulations only apply to persons who knowingly participate in the circumvention. I should give you the reference to that. It's page 607 of the bundle. And in a case like the present one, where one's dealing with a third-party finance party or funder, it's not likely that they're going to be knowingly circumventing the regulation. And the vice that the Regulation 28.3 is trying to get at is the possibility that, or one possibility is that the parties to the underlying arrangement will set it up in such a way that payment follows on from the end of the arrangement. And on the appellant's case, that would not be caught by Regulation 28.3, and that will be a serious gap in the coverage. On the question of the effect of termination, the Court of Appeal also observed in paragraph 65 of the judgment that if it were right that termination could make the difference between the bank's obligation to pay or not pay, that would create certain practical difficulties because the bank would not necessarily know what the status of the underlying arrangement was. Now, we had a discussion this morning along those lines in connection with autonomy, and I'll come back to that a little bit later. But the point also plays into this discussion about the consequences of termination, because a party in the position of UniCredit as a paying party might not know and might not be able to find out whether the relevant underlying arrangement had been terminated or had terminated or what its status was. And even if the bank is told of a termination, the bank may have no way of determining whether the termination is valid or what the reasons for it were, whether it's disputed, or what its effect might be on the future supply or making available of goods under the arrangement. And that's a particular problem, as the Court of Appeal recognised and as was discussed this morning, under letter of credit arrangements, where the bank would not normally be either expected or entitled to inquire into the performance or status of the underlying contract. Now, of course, in this case, it's said by Celestial and Constitution that it's all very clear and there can't be any doubt about their right to termination. And indeed, I think on the evidence, that was the fact of the termination was, in this case, notified to UniCredit before the payment date. But of course, the regulation has to be interpreted as a general matter, not by reference to the particular case. And if the appellants were right, as the Court of Appeal said, it would create real practical difficulties for the operation of the regulation. That's dealing with the question of object, and we say that is sufficient to dispose of these points, this particular point, because the object, it's right to say, the object of the lease is to make available aircraft in Russia. It is and always was. We do also rely on the effect limb of the test. We say that if one's asking what the effect of the leases are, as a matter of fact, 5 of the 7 aircraft do continue, in fact, to be available to the Russian airlines and, as far as we know, continue to be used in Russia. Now, of course, it is true that that's not the intention of the lessors. The lessors' intention is to get their aircraft back. And it is also, no doubt, true that they are being used by the Russian lessees in breach of the terms of the lease. Nonetheless, we do say that unless and until the aircraft are in fact returned, the leases do continue to have the effect, as a practical consequence, have the effect of making the aircraft available for use in Russia. So both on object grounds and on effect grounds, the leases are relevant arrangements. My Lords, I've dealt with those 3 criteria, if I can put it that way, as to why the appellants say these are not arrangements. I was now going to move on to look at the next question, which is, if they are arrangements for the purpose of the regulation, is there a connection with the payment? That being what I call the second condition when I opened it. And in particular, that raises 2 questions, which is, does there need to be a causative connection? And how is the issue affected by the principle of autonomy? Now, it's important to understand just how, or precisely how, the appellants put their case on this. Because what they say, and one can see this, for example, at paragraph 46 of Celestial's written case, I'm looking at it, page 58 of the key bundle. The way they put the causation case, if you see the end of the second line, they say the phrase, quotes, in connection with, denotes some degree of causal relationship between the funding and the supply of aircraft. The Constitution put it in a similar way. Now, one initial objection, an important objection to the way in which that case is put, is that it collapses the 2 conditions that we looked at in Regulation 28.3 into a single condition. Because if we look back in 595 to the regulation itself, what the regulation requires is a connection between the payment, or the provision of funds, and the arrangement, not, as the appellants argue, a connection between the payment and the supply. And that's what I mean by them collapsing those 2 points into one. And that's important because the fact that Regulation 28.3 imposes those 2 separate conditions is significant in the interpretive exercise when we try and work out what's meant by in connection with. Because one's obviously got different different operative wording for the two conditions. So what I call the first condition, so the specification of arrangement, uses the phrase whose object or effect is. And that's used to specify and limit the class of relevant arrangements. And by using the word effect as part of that, it is using, to that extent, the language of causation. But the second condition, in other words, the linkage between the arrangement and the payment or the provision of funds, uses a different phrase. It uses the phrase in pursuance of or in connection with. So you've got two contrasts here. You've got the contrast between the words used, the object and effect words used to specify the arrangement, and you've got in pursuance of and in connection with used for the link with the payment or the provision of funds. And then, as Lord Hodge was discussing earlier, there's a further contrast between within the second condition, which is a contrast between the words in pursuance of and in connection with, which, as a Court of Appeal with respect correctly said, must mean different things if they are not to be OTS. And to be clear, since the question was asked, in our submission, in pursuance of denotes, or rather an act which is in pursuance of something. That means an act which either carries out the arrangement or which causes or gives effect to the arrangement. So in connection with must mean something different from that, and it must also mean something different from object or effect. Because the draftsman has...
You say carries out or causes or gives effect.
Yes.
Carries out is giving effect. So it's two possible interpretations. It's causal, causing the arrangement, or carrying it out.
Yes.
I think, yes.
Yes. I mean, we would say either one of those would...
Yes, and the appellants say, no, it's just carrying it out.
Yes.
But that ignores the well-established other meaning of the phrase.
Exactly so, yes. So one has those, as it were, contrasting words used. One has to take it, have in mind when one then asks the question, well, what does the phrase in connection with mean here? And the parties have cited, as in the written cases, various authorities about the meaning of the phrase in connection with. And of course, we don't dispute that I mean, like any phrase in the English language, it can be used in a broader or a narrower sense. And of course, you have to interpret it in context. But there is one important point that comes from the authorities, which is that at least as a matter of semantics or ordinary meaning, the phrase does not imply a causal link. And that comes from Campbell and Kanoko, 2003, All England's. It's at page 996 of the authorities bundle.
Page
996.
996.
996 is the start of it. I'll just very briefly summarise what it was about. This was a case about an employee who'd been injured working on an oil rig. He brought a claim against a rig operator, and that claim was then passed down a chain of contractual indemnities to a subcontractor. And the indemnity that the subcontractor had given was an indemnity against liabilities, quotes, in connection with the performance or non-performance of the subcontract. And there was an argument specifically about whether that expression required a causal nexus. And if one goes to page 1001 of the bundle, paragraph 19 of the judgment, Lord Justice Ricks specifically rejected that argument. He said, paragraph 19, I agree that the words of the indemnity and particularly the connective links contained in the relevant part of the clause cover the facts of this case. The words throughout the clause are very wide, and the connecting links expressed are themselves of increasing width, ending with the words in connection with, which are widely regarded as being as wide a connecting link as one can commonly come across. In themselves, they do not express the need for causal connection, although they do express a need for a connection of some kind. Now, again, of course, each case turns on its own wording and context. It is nonetheless somewhat striking that in all the various cases that have been cited to this court in the parties' written cases, the appellants have not found any case in which a court has held that a causal link is a necessary component of establishing a connection, either for the purpose of legislation or for the purpose of a private law contract. The choice of the draftsman in Regulation 28.3 of using the language of connection rather than the language of causation cannot, in my submission, be regarded as just accidental or the product of loose drafting. We've already talked about, or already made submissions about, the contrast in the wording within the Regulation 28.3 itself. But it's also notable that where elsewhere in these regulations the legislators did require a causal connection between two things as a condition for the application of the sanction, then they said so expressly. And if one, well, a number of examples of that, but if we go, for example, to page 598 of the bundle, Regulation 30, you will see the form of wording used there. The end of 30, person must not directly or indirectly provide various things where such provision enables or facilitates the conduct of military activities. And we've given some other examples at paragraph 57 of our written case of other places within the regulations where expressly causal or causative language is used. And it is notable in our submission that the draftsman chose not to use that kind of language in Regulation 28.3. So, of course, the interpretation still needs to be tested against the legislative purpose, and I'll come to that in just a moment. But the starting point must be that there is no support in the wording of Regulation 28, seen in its context, for the appellant's argument that in connection with must be read as including or implying a causal connection. I should pick up another point which the appellants make in their written cases. They criticise the Court of Appeal for having interpreted Regulation 28.3 as applying where there is a factual connection, no matter how slight or no matter how tenuous. Those are not the Court of Appeal's words, those are the appellant's words. That, in my submission, is not a fair criticism of the judgment. The Court of Appeal did not say that any connection, no matter how slight or no matter how tenuous, would satisfy Regulation 28.3. The way they approached the case was simply to respond to the argument then being made by the claimants that there had to be a causal connection. The Court of Appeal rejected that as being a requirement, and the Court of Appeal also pointed out that the use of the phrase in pursuance of also indicated an intention to cast the net broadly. But having rejected the appellant's argument about causation, they did not go on to try and further gloss or further explain what connection meant. And the parties didn't ask them to do that. What the Court of Appeal did is they rejected the argument of causation, and then they simply went on to decide whether, on the facts before them, there was, in fact, a connection. And they were, in my submission, justified in taking that approach. As Lord Justice Singh said in Crown and Smith, which we mention in our written case at paragraph 45.1, he said, rightly, the words in connection with are ordinary words of the English language. They don't have a technical or restrictive meaning, and where the legislator has used plain and ordinary language in a sanction, attempting to rewrite it or redefine it or gloss it or expand it doesn't, in the end, help in applying it. There's only so much precision or explication one can practically give. And that's apparent from the way the appellants put their case. They say they rely on the London Luton case and the Coventry Waste case to say, well, in connection with, it could have a broader meaning, it could have a narrower meaning, and that may be true as a matter of principle. But beyond their specific points about causation and their specific points about autonomy, they haven't actually suggested what it means to say it's got a broader meaning or a narrower meaning, and they've not suggested how the Court of Appeal should have directed themselves as to the boundaries of what's a sufficient connection, what's not a sufficient connection, other than by reference to their point about causation and their point about autonomy, which I'll come to in a moment. And one of the points Mr. Shah made in his oral submissions is that he says, and Celestial says also, that if one doesn't impose a requirement for a causative link, then the expression in connection with becomes too uncertain to manage, he says, and indeed even says that it would infringe the principle of doubtful penalisation. Now, of course, as with any legal test, there may be some difficult questions of judgment in any particular case in deciding whether there is or there isn't a connection. But that, in my submission, is ultimately a question of application. It's not a question of interpretation. And the fact that there may be cases where it's difficult to know whether the test applies or doesn't apply doesn't justify a restrictive or special definition of the words used. And it is in our submission instructive to observe that this phrase, in connection with, as it appears in Regulation 28.3, by my count, it appears more than 90 times just within Part 5 of the regulations. And it also appears throughout other legislation. It appears in a number of primary criminal statutes. So for example, I mentioned a moment ago Lord Justice Singh's observation that in connection with is an ordinary phrase of the English language. Lord Justice Singh made that observation in the context of an appeal under Section 6.1 of the Fraud Act. Section 6.1 of the Fraud Act makes it an offence to be in possession of an article for use in connection, quotes, in connection with a fraud. And that was the context in which he said, well, it's an ordinary phrase of the English language. I mean, no doubt in a criminal case like that, it's a phrase that one would have to ask the jury to decide on. So there's no reason to gloss it or to narrow it down. Legislators evidently consider it an expression and a concept that both the citizens and courts can properly grasp without the need for any particularly complicated explication or qualification. And indeed, I mean, if anything, the concept of connection is rather more easily understood, at least by a non-lawyer, than the concept of, sorry, I may have misspoke, I said the concept of connection is more easily understood than the concept of causation, which of course is a notoriously difficult and controversial topic in the law. So all of that suggests an ordinary reading of it, untrammelled by the need to introduce causation. And just briefly, on the question of doubtful penalisation, which is raised in the written cases, the principle is not in dispute. We've set it out in our written case in paragraph 85. It's a very limited principle. Even if there's ambiguity in a piece of legislation, that's not in itself sufficient to engage the principle. We say anyway there's no ambiguity here. And given the extent and frequency with which this phrase, in connection with, is used throughout legislation, as I've said, not just in these regulations, but in criminal statutes, there would have to be something very particular, very unusual about the context here before the court could properly treat it as imposing a doubtful penalty. And as I've said already, exactly the same phrase is used in the Fraud Act, it's also used in the Theft Act. And Lord Justice Singh considered doubtful penalisation in Crown and Smith, but didn't think it was engaged in that case, said, as I've said, it was simply an ordinary of the English language. So that's dealing with in connection with, so far as the wording is concerned. Let me turn again to the question of purpose to make the submission that a conclusion that one can reach from the wording that a causal connection is unnecessary is also supported by consideration of the purpose of the regulations. The Court of Appeal obviously considered purpose in rejecting the need for a causative connection. And the easiest way to see the importance of not requiring a causal connection is again to consider the example the Court of Appeal gave at paragraph 64 of the judgment, which we've discussed this example already, but the example of a case where a supply or a making available is made, but is made to Russia, but the payment takes place after delivery or after the lease has ended or after the lease has terminated. So you've got the supply first, or making available first, and payment later. Now, obviously in that situation, the payment would not be causative of the supply. It could not be causative of the supply because the supply has already taken place. And so on the appellant's interpretation, which requires a causal connection between the payment and the supply, the payment would not be prohibited because it's not causative. Nonetheless, in that kind of situation, the purpose of the regulation is undoubtedly advanced by prohibiting such a deferred payment. And that is because, of course, if one looks at it, if one stands at the date of the payment, that the payment is going to be made, of course, by the time of the payment, it's too late to avoid the particular supply, which on this hypothesis has already been made. But that's not the only purpose of the sanction. The knowledge and anticipation of the prohibition would, or might, deter the supplier from having entered into that kind of arrangement in the first place, or from entering into future similar arrangements involving a deferred payment. Or if one turns the point around, which is the way the Court of Appeal approached it, if a payment is permitted, if it comes after delivery or after the lease is at an end, then the supplier or lessor can easily avoid the purpose of the regulation by simply making an arrangement for supply against a deferred payment. And as I've already said, if one's dealing with a supplier or a lessor who's not a UK person, who's not acting in the UK, then that kind of arrangement could be made and could be performed without any infringement of the regulations. So it is absolutely vital that payments should be caught by Section 28.3, even if they come after the supply or after the making available and therefore are not causative of it. Because if that's not the effect of Section 28.3, it loses most of its, or a large part of its, deterrent effect. And again, that seems to be a point which, in my respectful submission, the appellants have no answer to. I turn then to the next question, which is if it's right that no causal connection is required here, was the Court of Appeal right to say that there was in fact a connection on the facts of this case? And that primarily engages the questions in relation to autonomy. Because, as I've said already, the only, apart from causation, the only specific point the appellants take as to why the Court of Appeal was wrong to say there was a connection is that there can't be a connection in a situation where the payment is an autonomous payment under a letter of credit. Now, the starting point here is that each letter of credit was issued and each payment obligation was undertaken in connection with a corresponding lease. That much is not in dispute. As was recorded in the Statement of Facts, the letters of credit were issued as security for the lessee's obligations. We saw that. And this is fact 8. I think not all, but most of the letters of credit contained an express statement that they were issued in connection with the underlying lease. And that, we say, is in itself sufficient to show a connection between the payments subsequently made to satisfy those obligations, a connection between those payments and the underlying leases. That's a connection, an important connection. Now, the way the appellants at least put their case in writing was to say that no, because the nature of the obligations, nature of the obligation to pay is autonomous, if there is a connection, it must be regarded as a connection between the payment and the issuance of the LC, rather than, as we say, a connection between the payment and the lease. Now, it seems with respect there was some slight rowing back from that in oral submissions, because putting it as high as that gives rise to an obvious problem, because in many cases the payment of the LC will directly facilitate the supply of restricted goods. So, for example, if we have the example of the LC being used to pay ongoing rent, but it might also be used, for example, to pay the purchase price of an aircraft supply. And indeed, it might also, and it would be a common arrangement of the LCs, payment might be against presentation of documents of title, which obviously will be a very direct facilitation of the supply of aircraft. So it can't be right, and I think it's accepted that it isn't right, that autonomy is a silver bullet for the appellants, because the fact that we're dealing with LCs in itself means there can't be a relevant connection. But if it's not a complete answer, and it depends on the circumstances, well, then that gives rise to the difficulty that Lord Stevens and Sales were discussing, that if it depends on the circumstances, for example, if it depends on what the payment is for, then the bank or another finance party might not know that and might not be in a position to find out, and indeed, if it's an autonomous arrangement, wouldn't normally be entitled to find out, and so would be, I suppose, dependent either on its own ability to conduct extensive due diligence or on the willingness of the relevant parties to disclose the information to the bank. Now, one shouldn't also attach too much weight for these purposes to the autonomy principle. Autonomy means no more and no less than that the bank's obligation under the LC is to pay if and only if conforming documents are presented, and therefore the the obligation is to that extent independent of the performance or breach of the underlying contract. There's common ground, that's what autonomy is. But it simply doesn't follow that because the payment doesn't depend on the performance or breach of the contract, that the payment can't be connected with the contract. It's just a logical non sequitur. And of course, whilst the appellants say, well, the right way of looking at this is to see the payment as connected with the LC rather than the lease. And of course, it is connected. I mean, of course, the payment is also connected with the LC, but there's absolutely no reason why, for the purposes of the engagement of Regulation 28.3, one can't treat the payment as being connected both with the lease and with the LC. And indeed, it plainly is connected with both of them. There are also a number of further direct connections in the present case, which mustn't be overlooked. When I say direct connections, I mean connections of the kind that I'm trying to establish, which is a connection between the payment and the arrangement being the lease. One can identify at least three, which are also set out in our written case. First, by demanding payment, the claimants were enforcing their security rights under the lease. That's a connection between the payment and the lease. Second, and we saw this in the documents, that the way the LCs were drafted, the appellants could only demand payment by presenting a statement that there had been a failure to comply with the terms of the lease. And we saw one of those certificates. Now, of course, because it's an autonomous arrangement, the bank is not required, indeed it's not permitted, to assess the truth of the statement in the certificate. But nonetheless, the very fact that there is a need to present a certificate certifying that there's been a failure to comply with the terms of the lease shows a connection between the payment trigger and the lease. And then the third connection is that, again, this is a point we make in our written case at paragraph 60.3, that if a payment were made, the payment would discharge pro tanto the lessee's obligations under the lease. Because in this kind of arrangement, the payment by the bank is effectively twofold. It discharges the bank's obligation under the credit, and it discharges the underlying obligation under the contract. So those are all meaningful and important connections between the making of payment and the underlying lease contract, and they amply support the Court of Appeal's decision that there was a sufficient connection on the facts of this case. There are also a number of other contextual reasons as to why the appellants can't be right. Say that and this is the way they put it in their case, they can't be right to say that the autonomy principle has the effect of severing the connection between the payment and the lease. The first point is that if that were right, it would create a rather strange and somewhat illogical distinction between a bank that had financed a lease or financed performance of a lease with a documentary credit, I should say secured performance of a lease with a documentary credit on the one hand, and a bank that had instead given a standard guarantee, in other words, a see to it guarantee, as they're sometimes called. So essentially the same arrangement, but one is autonomous and one is not autonomous, and therefore it would seem on the appellant's case that in the former case where the bank gives a standby credit or a documentary credit, payment would be permitted because there'd be no connection. But in the latter case, where the bank has given a, what I might call it a conventional guarantee, where it is entitled to rely on the issue of whether there's been performance of the underlying contract, payment will be prohibited. But it's quite hard to see why, as a matter of the policy of Regulation 28, the sanction scheme should operate differently as between those two kinds of arrangements. Second, I made this point already. In many financing structures, payment under the LC will facilitate or enable the delivery of the contracted goods. And it would be very strange if autonomy was an answer to those kind of cases, and that the bank in those kind of cases was required to pay. The final point made by Constitution in relation to this point is to say, well, the Court of Appeal's approach is inconsistent, they say, with the need to treat letters of credit as equivalent to cash. And they rely on the fact that under the terms of the lease, the LCs were given as an alternative to a cash deposit being placed with the lessors. But of course, while one speaks of LCs being equivalent to cash, we don't mean that literally. They're not literally equivalent to physical money in the hands of the beneficiary. What we mean by saying they're equivalent to cash is they're equivalent in the sense that, provided there's a conforming presentation, the beneficiary has an unconditional right to be paid, just as he would as if he had cash at bank. But that right, like any right to be paid, is subject to any supervening mandatory law, such as a sanction, that would prohibit the bank from paying. One miscellaneous point, which I take out of order, but I'm reminded I should say something about it, is you were shown the commentary on Regulation 29A, which concerns insurance, and you were it was pressed on you that the guidance there should carry across into 28.3 as not applying to aircraft which had been detained unlawfully. Well, that shortly is dealing with a different regulation in different terms. We cover that point in paragraph 66 of our written case.
And it's interpreting a regulation which post-dated 28.3.
That's correct.
And the guidance post-dated.
Guidance post-dated as well, that's correct. Just to conclude on the section 28 points, just a brief comment on the written submission you've received from the interveners. Properly read, it doesn't actually make any legal submissions. All it does is to purport to draw to the court's attention what's said to be the impact of the decision of the Court of Appeal. It does that essentially by giving a number of anonymised examples, which are said to be said to show delays in the process of insurance claims, including delays in the obtaining of licenses. But since they're anonymised and since there's been no evidence in support of that, it's not really possible for us to respond meaningfully to that submission, or in my submission for the court to get much out of it. The one point we would make is that if the complaint is that delays are being caused by the time taken to process applications for licenses, that surely cannot be a reason to adopt a different interpretation of the regulations. If that's a problem, then it's for the legislature either to loosen the sanction if they think that's appropriate, or for the government to speed up the licensing process. But it can't have any impact on interpretation. So for those reasons, we say the Court of Appeal was right to hold that Regulation 28.3 prohibited these payments under the letters of credit without a licence, and that the appeal should be dismissed for that reason. That was what I was going to say on the appeal. I was then going to move to the cross appeal. I just have...
Yes. If you wish to start on the cross appeal, please.
Is the court finishing at 4 p.m. or?
The court will finish at 4, but if you wish to lay out your stall, as counsel often does,
I'll give the court.
Please feel free
I'll give the
to
court
do so.
5 minutes, if I may. Just perhaps by way of recapping the facts as they are relevant to the questions that arise under Section 44. So the situation is this. The amounts due under the letters of credit became payable, if Section 28.3 doesn't apply, became payable in March 2022. UniCredit did not pay them. The appellants then brought the present proceedings against UniCredit, claiming the unpaid amounts under the credits as debt or damages, together with statutory interest under Section 35A. And they also claimed declaratory relief about the effect of the regulations. And those proceedings were brought in 2022. Now, on the 13th of October 2022, and that's before the first instance judge had given judgment, a licence was granted and came into effect. And UniCredit paid the outstanding amounts under the LCs pursuant to the licence on various dates in the period 14th of October to 25th of November 2022. And thereafter, the proceedings were only concerned, and are only concerned, with interest on the late payment of the LCs and with costs. And those two matters, interest and costs, were the subject of an order in favour of the appellants on the 23rd of May 2023, it's page 178 of the key bundle, by which UniCredit was ordered to pay approximately £1 million in interest and also to pay costs. Now, it's now common ground, of course, that UniCredit's failure to pay the amounts in March 2022 was done or not done in the reasonable belief that it was prohibited from paying the amounts under Regulation 28.3 without a licence. So that's now common ground. And Section 44, you might just turn it up, it's at page 828 of the bundle. Section 44, as you know, provides subsection 2 that a person is not liable to any civil proceedings to which that person would, in the absence of this section, have been liable in respect of the, and I'm going to substitute omission for act, flying section 3. So there can be no dispute that under this section, UniCredit is not liable to any proceedings to which it would otherwise have been liable in respect of its omission to pay. And therefore, the question on the cross appeal becomes a relatively narrow one. For the purpose of Section 44, are the present proceedings, which claim interest and costs, are they proceedings, quotes, in respect of UniCredit's omission to pay the LCs? And it's that question which I propose to address your lordships and your ladyship tomorrow.
You don't have to prove an omission to pay, but you say the words in respect of are wide enough to cover it.
Yes.
Thank you very much. The court will now adjourn and resume at 10:30 tomorrow morning.